Hello, ladies and gentlemen. This is Scott Pollack, Chief Editor of the Critical Post Chicago Reporting, and welcome to another edition of our interview sessions. In today's interview, we have the distinct pleasure of interviewing a man who's got a Juris Doctorate from Southern Methodist University Law School, Mr. Harmon L. Taylor. This man is one of the most amazing finds that I have seen on the web after we made it an initiative of the Critical Post to find out what the heck is going on in this country, because from this seat and from what our small staff has been able to gather, combing all of the political websites, the alternative media political websites, the blogger content websites, listening to commentators left and right, everybody giving an opinion on radio and television. Our conclusion is that nobody had it right. There's a lot of blogger content websites out there that are talking about vast conspiracies regarding, the thing about the Act of Congressional Act of incorporating Washington, D.C. In 1871, that's part of a conspiracy, and that, the New York Federal Reserve is, beholden to the Vatican Bank, and all of this stuff. Now, in and of itself, some of these facts may be correct, but what's going on in the national conversation about the Constitution is incorrect, as best we can tell. And that's why, after watching Harmon L. Taylor on John B. Wells' Caravan to Midnight program, and like I say, we're a subscriber to that, and hat tip to John B. When I heard this man being interviewed, and I said, he's got it. I made the judgment that if anybody is correct about what the heck is going on in this country and why it is going on in this country, Harmon L. Taylor is that guy. Now, in terms of this man's mind, he is an amazing, I've got his bona fides on the screen here. This guy is amazing. And as you can see, I'm highly impressed by him. He is he got a bachelor's in physics in 1983 at Austin College, Sherman, Texas. In 1984, received a bachelor's in science in electrical engineering from Texas A&M. And in 1988, as I said earlier, he got a Juris Doctorate from Southern Methodist University Law School. And then he went into practicing law. But his computer background, which is amazingly impressive, he programs in it looks to here like over a dozen and a half current relevant computer languages. So when you take a computer programmer and electrical engineer's analytical mind and a discipline to pay attention to detail, which is what is required in these fields, and you couple that with a law degree, and you put it together in the talent of the intellect of Mr. Harmon L. Taylor, what you get is the kind of man that can actually tear apart the law the way it needs to be torn apart in such a manner so as to render us an understanding of what is the rule of law in this country. And the reason he went down this path is he was involved in two litigations, pretty big litigations, one in Denver regarding the Mura building bombing in Oklahoma City in 1995, wherein they accused Timothy McVeigh of and some accomplices of putting a truck bomb there. I don't have it up on the screen right now. I'm not sure what the first case was about, but the Terre Haute litigation, where I believe that Timothy McVeigh was executed after having been found guilty. In the Terre Haute litigation, Harmon was arguing for the preservation of evidence, and he was arguing based on the Constitution. But when he lost the case, based on the findings and the expression of the bench at that litigation, what it did was it changed his whole life. And what that led him to do was start tearing apart, how in God's name can I be in a United States court, in a district court or an appellate court? I forget which one it was. No, it wouldn't be. Probably be an appellate court, maybe. But be that as it may, how he could argue the Constitution, be 100% correct about arguing the Constitution and the principles about wherein constitutionally why they should have preserved this evidence, and to lose the case. Ladies and gentlemen, what you're about to listen to is probably the most cogent understanding from a man, one Harmon L. Taylor, as to what our legal reality is. Now, he's got a book out called We the Posterity, Voluntary Bondage, and you can buy it from him by subscribing to his email. Just send him an email saying subscribe to legal_reality@earthlink.net, and you can buy the book from him for, I believe, 1 ounce of fine silver. You got to send them 1 ounce of fine silver to get the book. We are extremely honored to have this man at the Critical Post Chicago interview sessions. He is a pivotal mind that not enough people know about, and we hope that Mr. Taylor will be a regular contributor at the Critical Post Chicago. So without any further from me, here's the interview that we conducted with Harmon L. Taylor. Stay tuned. And if that isn't a long enough interview introduction for you, ladies and gentlemen, I could go on for another 20 minutes about Mr. Taylor, but without much further ado, welcome, Harmon, to the Critical Post Chicago interview sessions.
Thank you. It's a pleasure to be here.
Harmon, the case of the Terre Haute litigation caused you to renounce your Texas Bar Association membership.
Yes.
And that was quite a life-changing event, as we've discussed on the phone.
It did change the life. The understanding of what we got out of that ruling and that experience wasn't just a career change, it was absolutely a life change.
Right. Now, please briefly touch on the Terre Haute litigation that you know it by, because you were filing that on behalf of folks that, like I said in this interview, to preserve evidence on behalf of folks that were a party to being a suit, who were the survivors of people of the Mura City bombing. Is that correct? So
yes.
So,
in fact,
explain explain that whole process and what happened.
The building shown on TV, this is where it started on the technological side. The building, as shown on TV, didn't appear to be damaged by anything that would be a ground-based point source, because that would be a spherical type of damage at some point. It looked like it was cut with a huge axe. So the eyebrow goes up and the head is scratched to say, okay, that's not a truck bomb. And of course, General Parton came in fairly promptly looking at the very same thing and said, there's no way that was an ANFO device. So that got me started on it. So they're not telling us the whole thing here. More study, more study. We meet the people, we watch what happens. And the thing that really got me going in that matter was the transfer across the state lines. And not to get into the details of the Terre Haute litigation, but just to thumbnail sketch that, the obvious problem, and we understand it the other way, is extradition. Everyone has an intuitive understanding of extradition. When the bad guys do it and run away and they get caught, what happens? The law says bring them back. And the answer is to where? And the answer is to the state having jurisdiction to prosecute. Okay, so we see this concept. It's in Article 3, Section 2. It's in Article 4, Section 2. It's in the Sixth Amendment. You don't export criminal cases. You bring the accused back to where the alleged crime took place. What happened in the Murrah Building case? The Murrah Building bombing case involved 2 explosions. There were 2 explosions, and everyone in Oklahoma experienced 2 explosions. There was glass shattered, there were buildings shaken miles away from the incident, which is impossible to happen for an ANFO device. It's physically impossible. You can't produce that result with that kind of a device. Something else other than that happened. What then had to happen by the people who wanted to sell a truck bomb theory? They had to change the location of the trial. How do you sell a 1 explosion case to a community that experienced 2 explosions? You don't. So the media literally was hired, prodded, instigated to demonize McVeigh to justify transfer. That's where we get the transfer. The transfer removed that trial way away from Denver. So far away that no one could ever possibly have had experience with 2 explosions. So that's how this thing ended up in Denver. And the question legally is, can you transfer a criminal case across the state lines? Constitution says you can't do it. So that's the basis for everything that followed in that litigation. Constitution says you cannot transfer a criminal case across the state lines. That's the first one. The second one is we go to Article 1, Section 8. We look at the legislative subject matters. This is what the Congress can act on and make law of the United States. That's one hat that they have, making law of the United States. They wear another hat. They have to. It's the equivalent of the state legislature. And where does that come from? That comes from the fact that no state has authority to participate in legislation on land owned by the national government. The only legislature in town is the Congress. So they have to wear a state legislature hat to do other things, such as define and punish homicide. We don't find homicide as one of the topics in Article 1, Section 8. As a matter of subject matter, the Congress has no authority to define and punish homicide as a matter of law of the United States. It's just not there. They have the authority to do it. It's under a different hat. And that's the exclusive legislative power. That's the state hat activity. So this is the second point in the Terre Haute litigation. It's fundamentally, what's a homicide case doing in a United States trial court?
Right. And so you, I remember from your initial interview with John. So you were there arguing on the first day or the first week or whatever the case may be, and then you got to a point in the interview, and you said that the judge, upon coming back the next day or the next week or whenever the next hearing was, it said, yes, you argued very, very correctly. Now, and then you said, now we're going to show you how it really goes.
Yes, now that was on appeal. That was in the Seventh Circuit. So there we are. We've gone through the McVeigh's been convicted. I submit the amicus brief in the appeal in the 10th Circuit. So probably it was in 97. I think your date there is good. The ruling didn't come out to 98, but I think they took their time on it. So it's in that direct appeal that I did the amicus brief. And good rumor has it there were about half a dozen of us who saw this issue of transfer a criminal case across the state line and did the eyebrow raise and said, what are you doing? Okay, then he gets the appeal. It supports the conviction and the sentence. The Supreme Court denies cert. He's shifted over eventually to the death facility in Terre Haute, Indiana. That's where we find him at the time that George Bush is elected. So he gets into office in January. Too much stuff going on. It's just not right to burden that group of people immediately in the transition. So we waited till March. Sent the letter to Bush saying, fundamentally, we're going to need some administrative assistance with this, because if you don't do anything, there's no way the court is going to have any reason to listen to us. What happens then is the announcement of finding about 3,000 some odd pages of information by a clerk that was doing something. And those were turned over to the formal official defense counsel for McVeigh and Nichols. And John Ashcroft said, we're going to have to grant a 30-day stay in here because we've just found all of these documents. Well, the irony in all of that is what we are doing in Terre Haute, Indiana, on behalf of the survivors is trying to preserve evidence. So indirectly, we sort of had a little bit of impact right off the bat. They give the 30-day stay. Now, that coincided with the filing of the Terre Haute litigation. I believe the announcement came out on a Thursday evening. East Coast time would have been 6-something if memory serves. We go back and find it. The actual Terre Haute litigation itself was filed Friday morning. It was filed and served Friday morning. So the timing on all of that was fascinating. And what they did, which it frustrated me at first, I didn't understand it. It frustrated me that we were filing this. It should have been nationally recognized litigation. And all of the media attention stayed in Denver. All the media attention was in. Nobody wanted to look at this case. Okay, didn't understand. The trial court handled it beautifully. There's no better way for the trial court to have handled this case. He said, here's a show cause ruling. I've read your petition. Fundamentally, I'm translating and condensing. He says, I don't get it. Try again. So the backup plan, if we couldn't stop the execution, was to get a perpetuation of testimony. The perpetuation of testimony is well recognized. The states do it. The United States court system does it. And it's basically taking a deposition without there being active litigation. The deposition is a discovery tool. You get discovery during litigation. We didn't have litigation that directly involved McVeigh as a witness or as a party. So we're saying we recognize all of that, and if you're going to execute him anyway, even though we think the trial court didn't have jurisdiction to try the case at all, and let's just leave open some room there. We still need to take his deposition. We want to perpetuate testimony. So the trial court ended up saying no, and some technical issues, no need to get into. Those were addressed and corrected by the Seventh Circuit. And the Seventh Circuit also noted two things, which is the padding and what I call my padded 2x4. The appellate ruling in the Terre Haute litigation is the padded 2x4 lesson. The padding is this. They recognized what we had done in the issue of standing. Standing is a huge critical issue in the United States court system. You can have all kinds of great ideas, but if you don't have standing, the court would be entering an advisory ruling, and they don't have the authority to do that except in some rare circumstances. Okay, they're not going to give us an advisory ruling. So issue of standing is critical. But we nailed that. How did we nail that? We got survivors of the bombing. Jane Graham was on the 9th floor when the building was destroyed. V.Z. Lawton was on the 8th floor, and it happens that V.Z. Lawton has a pair of his glasses in the Memorial Museum, and V.Z. has since passed away. So the two litigants in the Terre Haute litigation are survivors, actual people surviving the bombing there at the time that the building was destroyed. They were representatives of the entire group of survivors for the bombing. So we didn't have to name everybody as a survivor, as a plaintiff. We just sort of used representatives of that whole group. And that's Jane Graham and V.Z. Lawton. Do they have standing as survivors to want to preserve evidence of the bombing? Yes. Seventh Circuit said yes. And they went on a little bit about, yeah, that's, of course they do. And so that's nice to read. We got that one right. And they went on also to say perpetuation of testimony is quite good. Uh, we had cited one rule. They came back with two more rules. And this is the subtle message to the trial court. Trial court didn't want to do a perpetuation of testimony. And the appellate court said perpetuation of testimony is exactly right. And not only did they raise one rule, but here's two more. So they start off on the side of saying what you've done here is quite good. We recognize what you're doing. We want you to know that we see what you're talking about. Okay, it's the most effective way to teach me when they say, look, you're doing great here. We see this, it's all correct. And then the transition in the opinion occurs, and they basically communicate, sit down, fasten your seatbelt, it's about to be a bumpy ride. And they go on to destroy this case. They destroy it. What had we argued? Article 3, Section 2, Article 4, Section 2, the Sixth Amendment, and the difference between Article 1, Section 8, legislative power, and Article 1, Section 8, Clause 17, exclusive legislative authority. The state hat versus the national hat for legislation. In other words, what had we argued? The Constitution.
Right.
How did the Seventh Circuit then in the next, they were condensed about it. They needed to get a ruling out, I guess, and it came out on the weekend. It's either Saturday or Sunday that the ruling came out. Okay, that's unusual. In the next 2 or 3 pages, and this is the headlines. This is topical sentences of their next discussion. They describe our 100% constitutional case as frivolous, without merit. This is the one that grabbed me immediately. Of no authority, frivolous, without merit, of no authority, and ludicrous. We argued the Constitution of the United States in the U.S. trial court in Terre Haute, Indiana. And in the U.S. appellate court, sitting in Chicago, 7th Circuit, frivolous, without merit, of no authority, and ludicrous. I'm reading this opinion. I'm on the road. It's a wild weekend. I traveled pretty much from north to south to back to North Texas in that weekend. And I'm reading this opinion, kind of tired, and immediately shocked, and yet immediately under absorbing. There's some of the gum numbing medications over the counter. You put it on, your tooth or your gum goes numb immediately. It's absorbed instantly.
Yeah.
This is how this concept went in, and numbing is pretty good concept here. I absorbed it immediately, and my mind kind of goes numb. This is my mind talking to them. They're not there. I'm reading this where I was. And I'm telling them in the air, you're telling me that the Constitution of the United States is of no authority. Okay, I'm in shock at this point. I read the opinion, my mind is whirring about this concept of no authority. Okay, the shock wears off after a few days. I don't want to go through the details, but it was flu-like symptoms, and it was for 2 weeks, and it wasn't flu. It was a physical reaction to what I was learning here. And they took the time to teach me, and I can tell you right now, they had to have known how I was going to respond to it. They had to have known, and they taught me anyway. They basically said, we're going to learn you a few things so that we can teach you what you need to know. If you're going to act on the national level, and we find some impressive stuff here, they don't say this anywhere. I'm reading into between the lines. We find some impressive stuff here. We find an analysis of the Constitution that's probably some of the best we've ever seen. And we need to tell you that your premise is wrong. If you're going to spend this much time on this sort of stuff, and of course you're capable, because look at the work you do, you're capable. Now, we're going to teach you some stuff you didn't learn in law school. And they did. And they taught me some stuff. And it was a bad physical reaction to it. So then the shock wears off. They call it 2 or 3 months later. By August. The ruling came out in June. By about the end of August, it had worn off. That's immediately in front of, as you can remember, the events of S-11. September 11, New York, Pentagon, Pennsylvania. Okay, so I'm just getting over the one shock, and the whole nation goes into another. The timing there is fundamentally this. We started with the license issue, and this is what we're leading up to. We get this ruling that the Constitution is of no authority, and so they're telling me that it's not active right now. What's the thought that goes through the mind? The thought that goes through the mind when the fog clears and the shock has passed. Okay, we don't have a constitution. Sun is still coming up in the east. We're okay. Let's keep going on this. It's not new to them, so they've been dealing with this for a while. If we don't have it now, when did we lose it? This is a question. If we don't have it now, when did we lose it? And of course, I was fully aware from high school and study of then about the money. I knew that the money had changed in 65. It hadn't really soaked in on me what that meant, but it's starting to come to mind. Okay, what's the connection here between the money shift and the Constitution? Did my generation lose it? Well, in 65, I'm not very old. Okay, I can't take responsibility for something that happened in 65, and yet I don't feel responsible. This is during my generation. What did we do to hose ourselves? This is a question I had to find out. So I start studying, and we're just going back in time, back in time, back in time. I find events. Now that I know that the Constitution is of no authority, my mind releases. And it sees some things. Well, that's not consistent with the Constitution, but that didn't raise any objection that sustained anything judicially. So we go back in time, back in time. Where we end up with one of the dramatic ones is the election of, what was it, 1928? We had 9 elections that followed the Electoral College to the T. The first 9 of them were correct. The 10th one got into the popular vote. Nothing was said about it. They just changed it. You can't do that. You can't do that. It's Article 2 procedure. Article 2 procedure spells it out right there. Okay, they shifted it. The 10th election in this new system did not follow the Article 2 procedure. Okay,
just, because I'm not looking at the list of presidents and I don't have this memorized. Which president was that?
I'd have to go back and look.
Okay, I'll look for it while you're.
We go back and check and see. But it was that 10th election that did not. We had 9 of them that followed. It's in the book, and I just don't remember. The 10th one did not follow the procedure. So I look at that. Okay, that's pretty early on. Let's keep going because I found several before then. The path leads all the way back to Philadelphia. The path takes us all the way back to the beginning. And in the beginning, what we find is that they were objecting to having the authority to do any of this at all. The objection that resounded in the halls in Philadelphia from beginning to end is, from whence comes our authority to do what we're talking about? What were they talking about? Creating a new system. Why is there an objection to authority? Because this new system idea would be superior to the states. Nothing allows there being authority superior to the states. The states have no authority. Let's presume they had constitutions. We can come back and debate this point. They didn't really. But let's just say they did. There's nothing in that document, nothing in that authority that says there can be action to create a super sovereign. There can be activity to create an authority bigger than this entity. It's not there. So these ministers plenipotentiary for each state meeting in Philadelphia are saying, we don't have the authority to do what we're doing here. Well, it finally occurred to someone by the end of that convention, yeah, there is a way to do this. We don't have the authority, but there's an authority out there. And that's where we get the language that's horribly labeled a preamble. Okay, it's horrible language from the perspective that it should be recognized as the enabling act. And those who are in the counseling programs that immediately react negatively to the term enabling, we can call it the act that allows them to do what they're doing. The empowering act, if we need to go there. Legislatively, it's called an enabling act, and that's what that language is intending to be. And who does it recite as the authority? We the people. We the people. Okay, why is that? Because we the people are the only ones who have the authority to change this system. What is its structure in 1787 when this is going on? What is the structure of the national government? Articles of what? Confederation. It's a federal system. It's a by-agreement system. It's not a by-law system. It's fundamentally a democracy that's organized a little bit because the state said, like Benjamin Franklin is attributed to saying, if we don't hang together, we shall surely hang separately. Okay, this is the thought We've got to have a national defense pact. That's where we start the Articles of Confederation. We have to have a national defense pact. Okay, it's by agreement. There's no enforcement mechanism. It's a by
Okay,
agreement system.
let's stop there for a second because
Okay?
that's the point in the discussion that you had with John. I said, finally, somebody is explaining exactly what is going on. The people don't understand legal language, and you've been known to say, and you have said many times in the past, federal means federal, which
Amen.
is kind of like a conundrum, but people don't understand that. Is it Black's Law that discusses the fact, the definition of federal, that you get that from?
I start with Webster's 1828, and I'll
Okay.
tell you why.
Okay, go ahead.
He is the closest one to this time period, and there wasn't a lot of change. There was some change going on in the language. The language has always been under attack. But he preserved the concepts in his 1828 dictionary that were firmly in mind in the late 1790s. So we're talking a 30 or 40-year time period, and in that time period, there just wasn't a lot of change in understanding. So in the book, I go through a lot of terms that are actually from Webster's 1828 dictionary.
Okay, so then it was Webster's dictionary, 1828, that states that federal means by agreement.
Yes, we get it there.
And the crux of the matter is that when you use anything regarding money in the federal system, you're basically, whether you realize it or not, and we can get into where the statute was that created this whole consent thing, but you're consenting to a commercial contract by using that money, the federal money.
We're consenting to the choice of law that comes with that currency. Yes.
Right.
Yes.
We're consenting to the choice of law. And the choice of law is not the Constitution.
Correct.
Because it has nothing to do with consenting to a contract.
Correct.
Consenting to a contract deals with the Uniform Commercial Code, maritime law, and the United States Code, which is kind of like sister to the Uniform Commercial Code. Is that correct?
Yes. Let's talk about that distinction. At the time that this money system is changing, and they're in heading toward that, the recognition was, and the court was not going to let them around it, the court being the Supreme Court. The court was nailing them, saying, you've got two marketplaces out there. So they had to change both marketplaces. Honest weights and measures was being used in both marketplaces. And what are those? The national marketplace, subject to the United States Code, and the state marketplaces, subject to the state codes. Both of those systems had to be divorced from the then existing honest weights and measures. They had to be separated from that. And that's why we have the Uniform Commercial Code. That's what the Uniform Commercial Code does. It separates the original system that we had based on honest weights and measures and allows use of this thing called the Federal Reserve Note. And you may hear me call it funny money, and if that happens, this is what I'm talking about, the Federal Reserve Note. Here's what the UCC does. It defines money. And there's a list. This includes money, Federal Reserve notes, this, that, the other. It does not define the term dollar.
Right. Now, I want to ask you a question about this distinction. So, we've never been under a constitutional authority. According to your research, we have never been under any constitutional authority whatsoever.
That's correct. Nationally, there's never been a constitution.
It is something that the politicians and the lawyers who understand the system pay lip service to, and it's kind of like kabuki theater, is it not?
Yes, they pay lip service to it. If they understand the difference and still talk about the Constitution, then what they're trying to do is keep the lid on.
Right.
I'm not trying to keep the lid on.
Neither am I, because I've been looking for the legal status of what's going on in this country and why people are confused, plus all those websites that I sent to you, making all these claims, whether they're facts or fictions, whether we can corroborate this stuff or not. So, the crux of the matter of our legal reality, hence your email address, legal_reality@earthlink.net, which you came to finally discover after the McVeigh case, is our
Yes.
legal reality is the fact that if we use a note printed on paper that is issued by the quote-unquote federal government, that we are consenting to being governed by, we are making contract at that point. Whether we know it or not, we are making contract. Is that correct?
It's an okay way to think about it. It's not really a contract with the government so much. We do contract with the government. This is why the term federal is so important.
Right.
They function by agreement. If we use it, if you and I had a deal and we exchanged Federal Reserve notes, we've got an agreement that doesn't necessarily involve the state or national government, but our agreement is now to be governed by the law of the place called this state, the Uniform Commercial Code related stuff. Okay, so we would have a contract. We do whatever we want to, legally, and we trade Federal Reserve notes for that. Then our agreement comes up under their law, and that's how they control it. You see,
that's my point. So when we use anything from quote unquote the federal government and their money, we are consenting to being governed by the statutes in two places, the United States Code and the Uniform Commercial Code. And not only that, but by consenting, by using that money and unwittingly consent to being governed by those statutory authorities being held in place, what we're doing is we're basically entering into contract to consent.
Fundamentally, I mean, where you're headed is exactly right. We're consenting to it commercially.
We're consenting to it commercially.
That's what we're doing.
And not only that, but once we consent to it commercially, everything is legal.
In that system, that's correct. All of their policies apply. All of their policies apply. That's correct. And that's where they get it. See, it's not the wealth thing. It's the choice of law that comes with it, with the Federal Reserve note. It's the choice of law that comes with it that their appearance of power comes from. And I say appearance, we have control over what we use for a medium of exchange. This perhaps is the most important point with the book transaction. I use silver exclusively. There are brilliant minds out there that blast away at the money system, and they trade their work product, which is superb, for what? Federal Reserve notes. Okay, I blast away at the Federal Reserve note system, and I trade that for honest weights and measures. Why? To be self-consistent with what I'm teaching.
Right. Now let's dial that back for a second, Harmon. Now you got all these guys out there talking about sovereign citizens and this and that and the other thing, all this stuff. And they're arguing the Constitution and why the Constitution applies to the sovereign citizen, private versus public, blah, blah, blah. But they're couched completely in the wrong terms, are they not?
Completely in the wrong terms. Sovereign citizen is one of these concepts that we can affectionately and patiently refer to as an oxymoron.
Exactly.
A sovereign isn't a citizen.
Exactly.
And we don't want to go too far down this. Just to mention, there's already one sovereign. We don't need a bunch more. Okay.
Exactly right.
So what they're trying to say, and they've got bad terms for it, what they're trying to communicate is the notion that you and I would refer to as a freeman. They're trying to say I'm a freeman. And okay, that's a great place to start. It's a great political philosophy to have. But you don't have a freeman while you're using the Federal Reserve notes.
While you consent to contract by using a system of federal money.
That's exactly right. We've got a visitor here.
Hi. What's the visitor's name?
This is Soki.
Okay.
Soki is, and you may appreciate this, it's a Hebrew term for lily.
Yeah.
As in lily of the field.
Okay.
And she has just within the last 36 hours delivered at least 4 new kittens.
Oh my God. Well, congratulations, you're a new dad.
Thank you. I'm very proud of her. I've got 9 cats and 2 of them have just delivered. And anyway.
Oh God. Okay.
It's an interesting interruption there. Sorry about that.
All right. No, absolutely not. So, our problem is what people, what there's the liberty movement, the ascension movement, the truther movement, the patriot movement, the freedom movement, all these movements, and they're all reading all this garbage out there, arguing the Constitution, arguing, some vast conspiracy and stuff like that. And the only conspiracy that exists is the fact that the legal profession can continue, the legal profession, along with people in the media, people in accountancy, everybody's arguing the Constitution when the Constitution doesn't even apply.
Correct.
And so when George W. Bush said, and I forget which quote, when he did that, he said the Constitution's just a piece of paper.
Right.
He was 100% correct.
Absolutely correct. He had very competent counsel. Absolutely right. And he gets blasted for that. And what's he doing? He's trying to say, I'm telling you people what's going on.
Right.
And this is how we respond to the Supreme Court too. The Supreme Court are the masters of the masters. They're the professors of the professors. They've been teaching us our reality from before we had this reality. They've always been teaching us this reality, and people out there here are ruling by the Supremes they don't like, and they just blast away at the Supreme Court. All they're doing is confirming what they don't understand yet. And it's frustrating on my part because it misleads so many people. We need to be at the feet of the Supreme Court with a notepad saying, let's go over this again. That's why they put it in writing. We want you to go over this again. Study what we're teaching you. Study what we're saying. Take it apart, put it back together again. Please start to get it. And they do this year in, year out, year in, year out.
Now, can I ask a question?
Fire.
It's just something that comes into my mind. Does the case of, you've heard Congress ask when they're talking about confirming a Supreme Court justice and stuff like that, how do you feel about this and how do you feel about this case and yada yada. And one of the cases that is most prominently mentioned just about in every single Supreme Court confirmation is Marbury versus Madison.
Okay.
Does the Marbury versus Madison case come to bear? And explain it to people what it is so that we, briefly. Sure. But does the Marbury, isn't that the case that confers supreme ultimacy to the Supreme Court and usurps, quote unquote, the citizen or whatever?
Marbury versus Madison is a case where Madison was sitting on documents to be delivered to get people new offices. And Marbury wasn't getting his paperwork. And so the case is about the fact that he went to the United States, the Supreme Court of the United States, in a trial mode. He filed suit in the Supreme Court of the United States as a trial court to say, make the officer of the United States deliver that paperwork. And what the Supreme Court basically said is, yeah, we see exactly what you're talking about, but you're in the wrong court. We're a review court. We've got trial authority, yes, but you don't qualify as one of the states that can come in under original trial jurisdiction. You don't qualify for that. And so we're not going to do mandamus as a trial court. We have mandamus as an appellate court to protect and preserve our authority, our jurisdiction. But we can't be a trial court. And so we see your problem, and we're going to dismiss your case because we don't have jurisdiction. This is the fundamental thought that prevails over everything judicial. A court always has the authority to determine its authority, always. And this is fundamentally what started in Marbury versus Madison.
Okay, all right. So that's I was confused about that myself. But so then what we have is, Mark Levin has got this book, Men in Black.
Okay.
And how the Men in Black have been, perverting the Constitution and this and that and the other thing. Now, Mark Levin is one hell of a commentator. But Mark Levin himself either knows what you know and is deliberately not addressing what it is that you know and what it is that we've confirmed, that federal means by agreement, and that we've consented to this by using the money that is printed by the federal system. But he does talk about federalism quite a bit.
He is a very intelligent and committed individual to America and
the Constitution.
We need to be really nice here. He doesn't yet grasp the difference of what you and I are talking about here about the term federal, semantics. Mm-hmm. He sees a Constitution. He's got a world of support out there that still sees the Constitution. Of course, the Seventh Circuit in the Terre Haute litigation cured me of my red, white, and blue fever.
You're right.
And there are only two ways to go on this issue, and you've identified them. Either he understands it and he's intentionally misleading, or he just doesn't understand it yet. Right now, I'm leaning toward the latter. He's so sincere and so energetic. You've heard him. Everyone's heard him that's heard his program. He's so energetic. He's so animated about the topic that that can't be faked. I don't think that can be faked. He's one of the best actors going if he's faking that. So I default because of that, because of his sincerity, to the position that he and I should probably go have coffee somewhere when he's ready. It's such a wicked paradigm shift. It's such a wicked paradigm shift that people should not be compelled into this. The only people that need really to be compelled into it are the prosecutors and the jurists who are making decisions where the reality is what is raised. And they really don't have a lot of room to go. They have got to learn it. As uncomfortable as the reality is, they've got to learn it, and they really don't get a pass. And it's a very difficult thing to teach wicked paradigm shift to someone who's just not ready to hear it. So here's Mark Levin, and I try not to mention names. Here's a nationally recognized constitutionalist continuing to advocate the Constitution into a world in which the Constitution, by its application, hasn't existed probably in his lifetime. And so he's just one more. He's a court basher.
I love Mark Levin. I mean, he's very passionate. He's
very passionate. He's an American.
He loves this country.
Absolutely right. He loves his country.
And
he does. Absolutely.
And he's calling for an Article 5 convention.
Okay.
All of this stuff. But here, now you say that it was the 10th presidential election where this paradigm shift occurred. They changed the rules of the electoral college, and that presidency was John Quincy Adams.
Okay.
It was John Adams' son was the 10th presidential election, because I counted it's the election, the 10th presidential election, not the 10th president.
Correct. The 10th election.
The 10th election.
We
So
had
we
no,
got so we get George Washington 2 elections,
yes,
John Adams 1 election, Thomas Jefferson 2 elections. That brings us to
yes.
5. James Madison 2 elections. That brings us to 7. James Monroe 2 elections. That
Now, what
brings
year
us
is that? Monroe.
March.
When was he elected?
He was James Monroe was first elected. He served from March 4th, 1817 to March 4th, 1825.
Okay, we're right at the time because it's
And
late
then John
20s.
Quincy Adams, March 1985. So it was John. It was in the presidency of John Quincy Adams that they changed the electoral system, which is what triggered you to gain the understanding that at that point in time, a paradigm shift had occurred in terms of when everything flip flopped.
Yes, that was one of the critical indicia that kept me going backwards. I had found some things after that, but I got to that and was reviewing some of this, and I really can't tell you right now what triggered it. It's one of those things where you get an idea, and we can attribute ideas to many sources. Here's the idea, go check that. So I
Yeah.
checked into that and checked into that and checked into that, and here's this change. Okay, electoral college is functioning correctly, and now we've got a popular vote. Where does that come from? There's no amendment. There's no amendment to axe the authority of the electorals. The elector. What am I trying to say? The electors. Thank you. That's my term. Nothing changes their authority. So they have the authority to do the electing in that process, and they just flat got gutted. And here comes the popular vote. We've been popular voting ever since.
Well, let me ask you a question about this now. So that's the change.
That's the change.
All right. Now, the United States Code started being. Do you recall, or have you done the research about when the United States Code came into existence? Did it come into existence at that point, or was it before that?
I haven't studied the actual timing of when they started going from statutes at large to codification. You may have a date. It's not one that is in my mind yet.
Was it around? But it's been around since before the 21st and the 20th century. The United States Code goes back how far? Do you recall?
I'd have to get a volume and look at it.
Mm-hmm. Mm-hmm. Okay, I just curious. Just was
Yeah,
wondering.
I don't know, and it's a distinction. What we're talking about here is the distinction between publishing statutes at large generally, where the lawyer or the student of the law is going through the book to say, what did the legislature do? Well, they did this and this and that, and then the sequence is not codified. It's not put into any sort of organization. They've got the statutes out, and that's how the Congress actually works. It's third-party activity goes in to read all of that. Well, here you got some statutes on criminal law. Here you got some statutes on patents. Here you got some statutes on international matters. So let's put these in separate categories. So the party going through reading all of this doesn't have to wade through every single word you print to figure out whether you've got something on their topic or not. So the codification is actually third-party in its nature. And I don't know when they started doing that. The Congress speaks in statutes at large, and codification is extra from that.
So so all the Congress is doing. Now, let me ask you a question.
Fire.
Let's get to the meat of the matter. In 1945, I've been saying in editorials that the government is a corporation. Now, in 1945, there was the Government Corporation Control Act, which speaks to the evidence that, in fact, the government's a corporation. Now, I sent in the email I sent you, there's all this conspiracy theory about turning Washington, D.C., in the Act of 1871 and stuff like
Right.
that. Let's take a look at debunking that, okay?
Okay. The quick answer there. He's one of my favorite defense counsel in America. He's on a short list. A fellow named Larry B. Craft in Alabama. He has invested a great deal of his career debunking nonsense. And at his website is a wonderful discussion about the 1871 Act. To get to the bottom line of what his research told him, that came in and then got set aside a few years later. So it's never really been the authority that the Patriots have attributed to it. That's the long and the short of that one.
Right. So, but the governments are corporations. I mean,
It's a commercial entity. They've been declared into existence commercially. They were not created by an act of law. And this is the thing about the Constitution. The Constitution would be an act
State that again. Declared into existence
commercially.
Commercially. Okay.
Right. There are two ways to create something, and one of them is by commercial declaration, which is to put a sign out in the yard and say, I am now in business, and here's my business name. Commercial declaration. Goes on all the time. Perfectly legitimate. Okay.
It's legal.
Absolutely. It's the way business has been going on since business has been going on.
So the federal system or federalism deals with that commercial declaration.
Correct. They have declared themselves commercially into existence, which is what every commercial entity does.
And
Pick your favorite.
And they, I'm sorry, and they make money by declaring them a public service which deserves taxing authority.
The national system, in a nutshell, is a bank that pretends to provide governmental services.
Well, yes, we understand that. But, I mean, there's taxing authorities in every state.
Yes.
They are commercial entities. Springfield, Illinois is a commercial entity. Austin, Texas is a commercial entity.
Right.
Whatever. They've all declared themselves commercial entities.
Correct.
As corporations, and a corporation's business is to make money for whoever's a member of the corporation and its
owners, shareholders, equitable interest owners,
or people employed by thereof, right? So they declare themselves as commercial entities, and they are going to perform as their commercial entity a public service by administering quote unquote laws for the state within the border confines of that incorporation.
Right.
Is that correct?
They call it law. If you're talking about a tax, there's no tax in this system that functions any way other than federally.
Exactly, by agreement.
Absolutely. There's no tax out there.
You are consenting by agreement to be
taxed.
Correct.
That's it in a nutshell. That's the tax.
And they can ride that pony ad infinitum, ad nauseum for as long as they want because it's legal.
Correct. They can propose anything that's legal and have the people agree to it. And the courts are going to enforce that.
As long as you're using their money, and as long as you're you're taking part of the federalism or federated system.
Fundamentally, that's correct. There are some tax mechanisms. We can look at the property tax, for example. Mm-hmm. That existed before the shift in money, before we went from America to United States, in the change in choice of law. Before we went from a common law system, because we had that as the medium of exchange, to the maritime system where we had that as the medium of exchange. So a property tax, for example, is a very good example. That agreement exists even under the common law. It is an agreement. It is enforceable under that mechanism. So it's still 100% voluntary. So not every tax is directly related to the use of the funny money. Every tax that exists is enforced by the choice of law that comes with the use of the funny money. Let's look at a difference real quickly right there, because what did you just talk about? Under the common law, there's the subjective standard, and under the maritime system, the Uniform Commercial Code they were talking about there, the state, there's an objective standard. In the subjective standard, and I'll just pick one example to make the point. There's several examples. It turns everything on its ear. Under the subjective standard, if you and I were to talk about something, and one of us were to propose a deal, and the other one just simply went silent and didn't respond to it, would there be an agreement? Under the common law, the answer is no. Silence means no consent. Now you know what's coming. Under the choice of law, that comes with the use of the funny money, Federal Reserve notes. I call it funny money all the time.
Or federated
The,
money.
the federated money, the debt instruments. It's not an asset, it's a debt instrument. Okay. In the debt instrument choice of law, if we were to have an existing agreement and one of us were to propose a change and the other one didn't object to that, we'd have a different agreement.
In other words, not saying anything is determined as consent.
Correct. So under the subjective standard, now I've skipped over a step here and let's address that head on.
Okay.
I'm not 100% sure under the new system that if we created something from scratch and one of us went silent, that we'd have an agreement. Okay? The government kind of relies on that, but they typically get something in writing anyway. So it depends on, here's where I'm headed. It can depend on who the parties are. If you and I are out here in the field somewhere and you propose something and I go silent, it would be difficult to say, yeah, we had an agreement because of that. So that part of the common law, I'm going to say, still works. But if we had an agreement going under the common law and you proposed a change and I went silent, there'd be no change to it because there'd be no agreement. If we had an agreement and you propose a change, we're dealing in widgets and the quantity's 1,000. So you say, I want to send you 1,500, and I go silent. I've just agreed to receive 1,500 widgets. That's the difference. That's the difference. And there are several things like that between the subjective standard and the objective standard. They get turned on their ear, totally turned on their ear. And what's the difference? The medium of exchange. The one medium of exchange goes with one choice of law, and the other medium of exchange goes with the other choice of law. That's the kind of thing we're talking about.
Right. Right. And this is where people are confused.
Yes, and they're never told. I mean, who thinks about the money? Who knows about the money? Nobody. They're
Right.
experts saying, oh, 1 in a million may figure it out. Okay, well, I don't know that I would necessarily qualify for that. But what I do know, I'm trying to teach so that whatever this number is, it grows as fast as it can grow so we can identify the problem for what it is. We can't solve a problem we haven't identified correctly. You want to solve a problem? Identify it for what it is. We've got a money problem. And
Exactly.
it's not the wealth side of that. It's the choice of law side of that, and we as a nation don't understand that connection yet.
Right.
And we're
But the courts
slowly we
do.
are. We're going to.
But
We're going to continue to talk about it.
the courts
Eh,
understand that, right?
Yes. Way up top, they understand everything. That's what I'm saying. They teach, and we have to listen, or we don't learn anything.
Right. So it's not a conspiracy at
No,
all.
it's not a. Hell, it's. If we go into white lies, the banking system has never told us the truth. So, in the sense of the fact that there's more than one person and we're having the wool pulled over our eyes, we can call it a conspiracy, but conspiracy means crime. Is there a crime going on? Yeah, and perhaps we're the ones doing it. We don't have to use Federal Reserve notes. This is the thing. We get a choice. So we're opting into the bank's world by using their goods and services.
Exactly.
And so
Exactly.
if there's a crime, we may be committing it against ourselves.
Exactly. By using a federated monetary system.
Yep.
Not only is it occurring in the United States of America, or so named the United States of America, private banking money is being federated all over the planet.
Correct.
And the Uniform Commercial Code is the governing document of all that federated money. Is that correct?
If they're using Federal Reserve notes, that concept goes around the world. Do we want to talk about that for a minute?
Sure. Let's make the distinction. Okay. Because there's the Bank of China. They're using a private bank. They're creating their own currency.
Yep.
That's a federation. So in other words, every private banking facility that's acting in partnership with any particular government corporation anywhere on the face of the earth is using their own system of federation, which then opts those people into the Uniform Commercial Code.
If we're using Chinese money, I'll suggest that we're subtly buying into Chinese choice of law.
Sure, but they across borders, are they not conforming to the Uniform Commercial Code for trade?
If the, if they're using dollars, yes. Not necessarily if they use
Yuan or
the
renminbi.
yuan, right? Not necessarily if they're using yuan for the transaction. My default analysis would be we're going to Chinese law to figure out what we just agreed to, because that's unless that agreement says we're going to use yuan and yet we're going to use the choice of law of Switzerland or of The Hague or of the United States for choice of law, then the default choice of law for that transaction goes with the money.
Okay, Mel, let me ask you a question.
Okay?
Now, is it true or not true? And I don't know. The
I may
uni-
not know either. Let's find
well,
out.
let's find out. The Uniform Commercial Code is what governs transactions between nations.
Uniform Commercial Code applies at the state level. The Uniform Commercial Code is adopted individually by each of the entities called states. The Uniform Commercial Code is the way that the state marketplace was turned away from honest weights and measures and into funny money.
Okay,
That's
now. Okay, so then there is an international commercial code, is there not?
I'm sure there is. They've got international
But
agreements
that's not
and
the same thing as the Uniform Commercial Code.
correct. They're totally separate things. The
Okay.
international agreements will be published in the U.S. Code as international and other agreements,
Now,
treaties, and that sort of thing.
now then there's the people throwing the term around maritime law.
Yes, it's a good term, and this is what happened nationally.
Go ahead.
Nationally, they had to get us out of the silver, basically. It wasn't the only thing in general circulation, but it was the main thing in general circulation. That's the common law. So they circulated silver, and to change it at the national marketplace, they had to change the national statutes. So we see there the corruption in the term dollar directly. We don't see dollar defined at the state level in the Uniform Commercial Code. We do see it defined in the United States Code, and it's a corrupted definition. A dollar is 100 cents. Okay. If they take cent and say this is some weight in grains of fine silver, okay. What do they say? Dollar's 100 cents. A cent is 1/100th of a dollar. Round and round and round we go. There's not a definition. That's a cover story. So what's a dollar? Whatever we agree that it is. That's a dollar. Whatever we agree to. Monetarily, a dollar is whatever we agree to, but that's not the only effect that dollar has. On the international side, we're talking about where the authority goes, and the example that springs to mind on this is the BNP Paribas French banking house. DOJ tagged them with a huge fine for doing what? Trading with what United States defines as terrorist nations or terrorist states or businesses supporting terrorist states. They go on a list about who you can't trade with. Okay. So we just call them the terrorist entities. Whether they're governments or commercial, we just call them the terrorist entities just to put a handle on it. Okay. The BNP Paribas transaction involved people over in Europe, didn't have anything to do with the United States, with people over in the Middle East, didn't have anything to do with the United States, except for one thing. That transaction went through a phase that used, and I'm sure it was electronically. I don't know this, but I'm sure that it's just electronic. Electronic what? Electronic labeling of dollars. The transaction went electronically through one phase where they used dollars. And that transaction ended up benefiting or dealing with terrorist entities. That's my term. They may have one like that. But it went to a spot where the law of the United States says you cannot do that. So the French banking house, huge French bank over there, got tagged in the United States, in the United States court, for a transaction that had nothing to do with the United States. How do they get jurisdiction? They use dollars.
Because they use dollars.
They used dollars. And that was it. That's all they had to do.
Right.
Okay, that's the connection. And that's the international connection. So that's what I'm saying. If we use Japanese yen or Chinese yuan or the German money or the French money, by default, if nothing else is said, then we can presume that to be the choice of law.
Indigenous to that particular country.
Right. And so if you and I were to trade with
So
Germany,
they may have their own version of uniform commercial code in their country.
Absolutely. We buy into their choice of law to say we're going to use your money and not put a choice of law term in there.
Right.
So the money dictates a choice of law.
So now, when there's this big to do about the BRICS, you've heard.
BRICS Bank, the AIIB
right.
stuff, sure.
Oh, sure. So now, if all of a sudden all of the quote unquote Patriot movement people, the Liberty movement people, the Freedom movement people, the Truther movement people, the Ascension movement of people, all of a sudden they start to decide, well, we're gonna show you, we're gonna start using the Chinese renminbi. We're going to trade amongst each other with the Chinese renminbi, and the heck with the United States dollar. What they don't know is they're federating themselves with Chinese law that they have no clue what they're agreeing to.
That's exactly right. If the
correct?
Chinese wanted to enforce that, I'll tell you they probably could.
Probably.
I'll just put this at 99.9% certainty. What I'm saying is I haven't studied it, and there may be a clause somewhere that says if it's in this location or that location, we don't care. But as a default position, the people out there using Chinese money are adopting Chinese choice of law.
Because everybody's got their system of federating paper money.
And they're all doing it.
They're all doing it.
Correct.
Private banks having a great time with debt money, debt-based money, whether they say they're going to back it with gold or not. It does not matter, because the Chinese have a debt clock. The Russians have a debt clock. They're trying to bankrupt the governments and force them into being vassals of the private banking sector, because that's what's going on.
That's what's going on. Yeah, the Western European banking system, under which we are a branch bank, United States, is a branch bank of the Western European banking houses. Okay, they want to rule the world. They're doing a pretty stinking good job of doing it.
I would say. I would say. Now, okay, so we understand that when you federate something in legal terms, you are saying, I agree.
Yep.
Or by consent.
Correct.
So
it's a commercial matter.
It's a commercial matter.
Right.
So, as people living in the United States, the reason that we are, and I don't want to get into your expertise here, but the reason that the IRS is legal and can do what it does to any American person, notice I did not use the word citizen, but any American person, and in person even is an interesting legal term, but a person living in the United States of America, or a peoples themselves, if we're using these little green pieces of paper, as they say, we are by consent opting into a commercial system whereby the IRS can do exactly what they've been doing for all this time.
It's close to that, and it's an area in which I teach, and there's a lot of stuff to cover to get the mind around the income tax thing. I used to be really open about income tax, and the problem was the cobwebs remained and the thoughts were just added. So the legal reality didn't use to displace the other thoughts, but just as an add-in, like on a browser, just a supplement of what the ideas were already there. And the mind didn't understand what the teacher was teaching on the receiving end. So that created problems instead of solutions. So I don't do that anymore. I just teach in the private circumstance. Now, the question is, does the use of the Federal Reserve note create an income tax obligation? The answer is no. The use of money by itself is not sufficient to make one a taxpayer. Okay, one has to agree to that commercially, and that's where all the taxpayer stuff comes in. It is agreed to commercially. It is 100% voluntary. That part of the marketing is correct. They couch it in a distracting term. They say it's voluntary compliance. Well, that's true. It's just not the whole story. Voluntary obligation is the rest of the story, and they can't go there without, yanking their own rag off the bush. They can't get into that without saying where the obligation starts. And that's the part I can't get into because it's a rather lengthy discussion.
No, I don't want to get into into all of that, Harmon.
But
I
where you're
want to.
headed is exactly right. And the point is, being a taxpayer is legally, commercially, 100% voluntary. We can stop volunteering.
Right.
We just have to want to badly enough to study it, and then want to badly enough to take on the debate. We're dealing with Pharaoh. We tell Pharaoh, "Let me go," and Pharaoh says, "You're kidding me. I'm not going to let you go, or I'm going to fight you for it." So we have to know what we're doing to engage that debate.
Right. Now, so what's going on is we have a bank that is in full partnership with a corporate government that they call the federal government. Most people are used to using the term the federal government in
Perfectly
Washington.
good term.
Perfectly good term in Washington, D.C. And all of the stuff that's going on between the federal government and this private bank called the Federal Reserve is 100% legal because it is by agreement. Now, the other thing is this. In order for people to understand what they've consented to, and in order for people to understand that they've consented to the Uniform Commercial Code or the United States Code or however that is termed, they can opt out of that consent to some degree if they can find a means of exchange between each other that system can't track or whatever. Am I going in the right direction?
You're headed in a very good direction. There's a little bit of mix of use of money to the authority. There is that. It's not quite as direct as that. If we want to get loose from this federal system, one of the most essential things we've got to do is stop using the bank's money. So on that point, absolutely solid. If there's a point that America could benefit from learning, if they could absorb immediately a concept and act on it, that one concept is we got to stop using Federal Reserve notes.
Unfortunately, most people cannot accumulate enough whatever wealth,
Right.
federal money, whatever, to get a mortgage, to buy a house, to pay their landlord if they're paying rent. There's not enough of the citizenry in the country, citizenry in the federalism system. They are citizens if they consent. So
Right.
my point is that there's not enough citizens to I can take my silver and say, listen, I want your book. I'm going to send you. You say you want 1 troy ounce. Well, I don't have pure silver. I've got old junk silver coins. How many will you take in return for your book? And you say, oh well, send me 3 or send me whatever it is. In
Yeah.
whatever denomination. As long as you and I agree to that, then you'll take my silver. I'll take your money. What we're dealing with is the difference between honest weights and measures and a seigniorage of money that inures to the benefit of the Federal Reserve System.
Correct. And that's the difference.
And that is precise legal terminology that I'm using there. It inures to if you use their little green notes, it inures the seigniorage of that system inures to the benefit of the Federal Reserve.
Sure. Yeah, and that's a privately owned banking house.
Exactly. I mean, we've had Bill Still. I don't know if you know Bill, but
I haven't met him yet. He comes well reputed.
He's been studying, and he's confused because he talks about the Constitution still. He's still talking about the Constitution.
Well, we'll talk to him.
But we can get Bill on board with us. But but that's the crux of the matter, isn't it, Harmon? It's if we use their money, we're in essence going in some form or another. We're agreeing to be governed by the United States Code and the Uniform Commercial Code, and it has
Yes.
nothing to do with the Constitution of the United States whatsoever.
It has nothing to do with the Constitution. It has nothing to do with what we do at the voting booth. It has nothing to do with what we do as a jury panel member.
And
It
it's
has nothing.
completely legal.
Absolutely. And we do it 100% voluntarily. This is the thing. It's 100% voluntary on our part. Now, you make a great point. We don't have enough momentum in an alternate money system right now to do what has to happen. We don't have that yet. It's a generational problem. But
It's a
to
multi-generational problem.
exactly, that's a better term for it. It's a multi-generational problem. The answer is someone has to start that. And it's already started. It's very exciting to hear about these businesses. Yeah, we've been hearing what you're talking about, and we've been doing silver for 10 years, or we've been doing silver, we've been in business for 25 years, and we've always done silver, that sort of thing. So the small business owner is the solution. The small in the small business community in this country has always rested the solution. And when the small business community says we're going to start allowing this, whether the state government does or not is irrelevant, we're going to allow our clients, customers, patients, and patrons to pay our bills with honest weights and measures. We have the beginnings. John Wells is talking about, well, where does the change start? He used the term revolution. Where does the change start? And the answer is with the transaction with small business owners. That's where it is. It's very quiet. We don't say anything except let's trade in honest weights and measures. And then all of a sudden, what happens? The community starts trading in honest weights and measures among themselves. That pushes out the bad money. It won't push it out completely because there's certain things, the phone bill, the gas bill, the water bill, these sorts of things. Are they going to switch over? No. They're so addicted to this other that they're just stuck. The only way to change that is to put up a business that competes with them. So the next Apple or Windows entrepreneur that starts a computer system, okay, it'd be a phone system. It started in the garage. We always going to trade in silver. So that small business that provides that service is the only way we're going to get around this. It's the only way. We have to have those services continue. We're not going to shut down AT&T. Sorry, not going to happen. We're not going to shut down Ford. We're not going to shut down American Airlines. Not going to happen. And they're always going to trade in the Federal Reserve notes. So what has to happen? Someone has to compete, and that's the small business person. So the small business person that gets into the mode of America first, as passionately as Mark Levin is passionate, and say, I've got to do this because this is for our country, and do it for that reason. Now the small business becomes a big business. They compete with the Federal Reserve note business. Federal Reserve note business goes out of business, and we've always had the service. It came about how? Commercially, the American way. Start in the garage, build it up, do right by America, and what's going to happen? You're going to profit, your employees are going to profit, your shareholders are going to profit, the whole community is going to profit and benefit. Why? Because you did right by America. And we're seeing that. It's extremely exciting. It seems to me to be on the front edge. I think we're on the front edge of it. We're going to see more and more of it. It's very exciting.
So to sum up the whole crux of all this matter, because I can sit there and I've got it up on the screen over here. I can sit here and recite all of this garbage that is on the Anti-Corruption Society, Judge Dale, this and that and the other thing. All these people, right?
Right?
The king of all these. The Social Security is not insurance or contract, nor is there a trust fund. And then they cite a case. There have not been any judges in America since 1789. There have just been administrators. All of this is a bunch of nonsense because it doesn't address the central issue.
Correct. Exactly. True or not, it doesn't take the mind to where the mind needs to be. That's it in a nutshell.
It is a bunch of garbage that people are filling their minds with that they have no business paying attention to, because the legal reality, Legal, by the way, folks, that's legal_reality at earthlink.net if you want to talk to Mr. Taylor and ask him questions. The legal reality is that we have unwittingly consented to being in a system that is not of honest weights and measures, that is governed by the United States Code and the Uniform Commercial Code by using the money in a federated system. Is that a precise statement?
Yeah, that nails the essence of the problem right there. We use their money, we pick their rules.
That's
we vote
it.
for them. We use their money, we vote for them.
Right. Now,
that's what it comes down to.
Yeah, and now the other thing, and let me ask you what your opinion is of this, Harmon. We're about to, it's going to take a while to write it, but there's got to be a newspaper in this country that informs the people correctly. Which, you can, in other words, the things that you and I are talking, I as a newspaper editor, be it an electronic newspaper, and a broadcast submitter, be it video on YouTube. I, as a newspaper, talking to you as a legal expert after having woken up to the fact of what it was that you ran across in your work with the Terre Haute litigation and what you came to grips with and the research that you've done. Where I'm going with this is the newspapers themselves, because they don't understand the journalism that's going on, the journalist writers, they don't understand what they're part of. Nobody understands that they agreed to this. And they're all sitting there, flicking tongues back and forth. Nobody knows that how all this came about. So there has to be a paper that starts to inform people correctly. Otherwise, the papers are absolutely worthless. What's the difference? What's going on then? You can't extricate yourself, right?
When you're fed nothing but garbage in, there's nothing in the mind to produce but garbage out.
Which is why I admire the fact that you're a computer programmer and a lawyer at the same time. That's a stunning that's a stunning career path that you put yourself on in terms of school, because legal language is very precise. Well, so is computer programming, but you have to look at it in that precise nature in order to understand what's going on.
The legal terminology this day and pretty much the codified statutes is extremely semantical.
Yes.
We cannot presume we understand the term until we see its definition.
Now, where I was going at the start of this, and I don't want to ask you that last paragraph, is the vote. Okay, the Electoral College was changed, we've determined, somewhere around John Quincy Adams, the 10th election, as you say.
10th election.
Now, the other thing is this. People don't understand, and you and I discussed this on the phone, that they don't really have a true vote.
They have no vote. Politics in America, United States, is irrelevant. This whole system's been neutralized.
But what I think I remember talking to you about is the vote of no confidence. In other words, if you can only say yes to that or yes to that, but you can't say no to either one of them, other than by staying home, which is not saying no at all, because in this system, if you stay home, you've consented.
Yes.
You've consented.
Fundamentally, politically, that's
politically,
correct.
you've consented. So if you don't have a vote of no confidence that can say no to either one of those things, and if part of the counting calculus isn't arguably at least 50% of the people who stay home, who are eligible whether they're registered or not, if that vote of no confidence isn't in the system, even under the current consent system that we're in, you don't have a vote.
No real choice there. Pick banking party 1 or banking party 2. You're getting the banking party, and this is how the system has been compromised. It down that path, we can say, oh, we got to go fix this and act politically and get that fixed. Maybe not. And I say that in the same breath as saying, where we understand it's a federal system, we understand that the elected officer cannot compel us into agreement. The elected officer also cannot get us out of an agreement in which we've already volunteered.
Right.
So the politics fundamentally are irrelevant. The individual at home is the greatest source of the problem and immediately the greatest source of the solution. Either the individual has consented or not. Who is holding office doesn't matter. And that the exception proves the rule. It doesn't matter who's in office. It doesn't matter who's doing the legislation, for example. It doesn't matter who's doing the executive activity.
It's just one big piece of theater.
It is. It's theater and it's commercial. The legislatures propose deals. The individuals and the entities, commercial entities, will either consent to those deals or eventually, and we're seeing some of it, wake up to the fact that they can say, I actually have a right not to contract. That's the right. That's the correct way to do it. I put not in parentheses. But the right to contract includes necessarily the right not to contract. It's the same concept. So we're getting to the point slowly, painfully, excruciatingly painfully, slowly in times, the reality that we don't have to agree to the legislative proposal, and it just matters that we know we're dealing with a proposal. I call it Monty Hall's let's make a deal. Okay, some people, well, who's that? Okay, we might have to break out some TV archives to get to Monty Hall's let's make a deal.
Well, a lot of people don't, that's a, IMDb database, just look it up, folks. But
and so, yeah, there you go, they'll find it. The thing is that's what they do. Let's make a deal. We propose this. Wouldn't you like for us to regulate you this way today? Wouldn't you like for us to regulate you this way tomorrow? Well, no, actually, we don't want that at all.
And
okay.
And isn't it so, Harmon, isn't it so that even the captains of our industries, like the guys at the head of Lockheed Martin or the guys at the head of Boeing, they don't even know this stuff.
I expect at that specific level they may have counsel that does know. Now, I don't know about the business people. One of these days,
the middle managers, all these people, none of these people understand this.
Middle-level management and down will not understand it.
Never.
Way up at the shareholders won't. The general shareholders. The closely held corporation, there's a chance. But the big guys way up top, Fortune 100 companies, they probably have access to legal minds who do enough international activity to understand exactly what we're talking about. They would come in here and say, yeah, you guys are all over this. Okay. Less companies that are not quite that in tune, that connected, no, they're not going to understand it at all. The mom and pop shop on the corner are not going to understand it.
Right.
The Fortune 100, the Fortune 50 companies probably do, but I don't know. The lawyers probably do, and all the banking lawyers should. The banking lawyers who don't understand what we're talking about need to find a different career. Bless their hearts. They have to understand this because the bank depends on their understanding the game. Okay, so there may be some people in companies like that, but you get to the street corner things, the franchise deals, the smaller businesses. They don't even know the question to ask. So that doesn't mean anything. It's right. Just they believe what they've been taught.
Right, and
that's what we're saying.
And let's go back to something in the Federalist Papers. Let's call it the natural aristocracy, whatever you want to call it.
Okay.
The professors in the law universities, the certified public accountants, most of the doctors in the country, most of the lawyers in the country you didn't understand it when you graduated Southern Methodist University.
That's correct.
It wasn't until you argued that case and got slapped with of no authority.
Right.
That it was that you went to investigate this.
That's exactly right.
In other words, the people that are leading our society don't even understand the concept of what federalism does.
Correct. I'll agree with you on that 100%. Right now, today, the people that are doing things in the communities, be it political or commercial, we're talking Greek. Now, there are a few that understand, obviously, but the vast supermajority, that's going over their heads, saying,
Now,
"What are you guys rambling on about?"
let me ask you a question. Let me play devil's advocate. Is there a lawyer that you've come across that have tried to challenge your legal definition of this and has argued against what it is that you're talking about here in terms of this whole idea of federalism and federation and what federal means? Is there somebody that has argued against you?
Let me, against me, yes. In my individual cases, of course,
Not in
that's.
your individual case, but have had conversations with you. I mean, what's the
Oh, academically, outside of the
yeah?
judicial forum.
Yeah, outside the judicial, academically, is there are there people that hold a counter view to this?
Sure, I hear from them from time to time. The label I use for them are constitutionists,
Mm-hmm.
and some of them are telling me that I'm the problem because I'm saying there's no constitution, and there's nothing to do there. I cannot reach that mind. I don't. I have long since excused myself. I used to feel responsible for it. Well, what's wrong with my teaching that I can't get to that mind? There are certain minds I'm never going to get to, and it's okay. Why? Because the minds that this conversation reaches are the minds that are the leaders who are going to say, "Holy Toledo, we've never heard of this before, and it's making immediate sense to us. We're going to go take a vacation now and get our mind adjusted. We're going to absorb this hit and then come back and see what we can do." And the benefit to that is it doesn't take very many people. It doesn't take very many people. So will this message reach the masses? Not any time in the next 2 generations, but it'll reach the leadership that it's supposed to. So the numbers will be small, but the things will be adjusting. Yeah, there are people that get on the email and say, "Well, you're talking about this and you're talking about that, and you don't know what you're talking about." And I can't reach them. They want me to debate them into a different frame of mind, and that won't happen. When they get up to the point of asking questions, when the mind is up to accepting, maybe it's okay that I re-challenge my presumption over here. That's when I can teach them. When it's okay to challenge self, when it's okay for self to be on the line and not be threatened, we get cognitive dissonance so fast because self has to be protected. It's a death of self experience to go through this. We have to turn loose of that part of ourselves that has been lied to. They're not easy. They're not easy at all. But most people rebel against it. And so it's obviously the party giving the information that's the problem. It can't be the party hearing it who's just dead wrong. They haven't had my experiences, and they're not going to hear it from anybody that everything that they've thought and believed and taught and built their lives on is just a lie. It's a wicked paradigm shift. Yeah, I get debate like that in the email from time to time, and I'll engage that discussion for a little bit. It's an emotional issue. They want to get off track. They want to
There,
get
yeah,
emotional,
yeah,
and so the mind is not ready to make the adjustment. So I don't spend a lot of time there.
yeah,
I,
yeah. It's amazing, But like I told you in the phone call, when I heard you talking about this stuff and having been exposed by a good friend of mine who is no longer with us, Justin Garriott, who was a very ferocious paralegal in this world of federalism, if you will. After having listened to you, and I went, he gets it. We've got to get this guy on the air. Let's let him explain it in as plain as terms as possible, so that people can start to get their minds around these concepts. Because what we have is we have a problem with the internet, and the internet is probably one of the biggest sources of bad information as well as the biggest source of good information. It's a double-edged sword that's ever been devised. So we have a lot of bad information out there, and we have a lot of, shall we say, agent provocateur
A lot of agent
activity.
provocateur activity, and it ensnares a lot of people and costs a lot of people a lot of money annually.
Yeah,
Yeah, a lot of people victimized, and it sounds good, and they're not in a position to filter it. It's an emotional response to an emotional position, and so what you and I are doing here is trying to cut through a little bit of that into the objective part, and say, yeah, this is a wet dish rag to the face, but you really need to start to get your mind around this so that you can understand the problem. Because
right.
until we understand the problem, we cannot solve it. To understand,
Impossible.
yeah,
Absolutely impossible. Absolutely impossible to solve it if we don't understand what the problem is to begin with.
exactly.
So to bring this to a summation, this part of our discussion, because I'm going to want to talk to you many more times,
I look
Harmon.
forward to it.
Because we do need a legal mind that understands how to take this stuff apart and put it in common terms so that people can begin to get their mind. And we're going to have to repeat this many times. This process
Yes,
must be repeated.
that's exactly right.
The word federal means by agreement.
That's
If
correct.
you use a Federal Reserve note, then you are consent as a means of exchange of quote unquote value. If you use those things, then by virtue of contract, you are consenting to the laws or the statutes or regulations surrounding the exchange of that medium, because that medium of exchange in itself is governed by a maritime system in the United States, which is part of the United States Code and the Uniform Commercial Code, and therefore you are part of that system. As soon as you use it as a means of exchange, you are consenting to it.
That's it. And it's the kind of thing you can stop with every transaction. It's sort
And
of like
they
stopping.
never told anybody that they were consenting to anything,
Correct.
which is
That's
the kabuki theater part of the whole thing.
correct.
Nobody
We
in your school told you, hey, you better watch what you're using there. Because if you use that stuff, you're consenting to all this stuff over here, and it's got nothing to do with the stuff over here. Nobody told you that because the teachers themselves
didn't get it.
don't understand it, didn't get it, didn't take it apart, and there's not a lot of lawyers
There are not a lot of lawyers. There will
that
be more. You're going to reach them with what you're doing. You're going to reach them,
we
and they're going to
certainly
say,
we certainly hope so, Harmon. I mean, uh, and the Constitutionists, there's nothing we can do about those folks. I mean, people, Mark Twain said, it's easier to fool someone than to convince them they've been fooled. I've used that. It's probably one of the most relevant quotes ever since, excuse me, ever since I started this whole endeavor, broadcasting and putting these broadcasts on here, because I wanted to get what's our, gosh darn it, what's our status? Until we understand our status, we cannot know where to go. That was my whole thing. And I chased down this road and chased down that road. And then there you were. And I went, there's the guy. We need to get him on the air so that the Critical Post Chicago can begin to start informing folks of what their legal reality is. It has to start somewhere,
it has to start somewhere.
you know. And this is, and by the way, folks, it's a free service. If you want to support our efforts at the Critical Post Chicago, well, you can have Google pay for it. Just go to the head page and click an ad. Have a good time. And unfortunately, we'll take their Federal Reserve notes, and I will do with them what I will. But on that note, Harmon, there's a lot more that we can talk about here, and we've certainly taken up enough of your time today. But I want to have a lot more discussions with you
I look
regarding
forward to it.
what our legal reality is. Is there anything that you're following right now that's of particular interest?
At the national level, not really. They're the cases that come through from time to time on issues that I'm watching and applying will be particularly significant. I guess one of the more recent cases of huge significance is in the transportation area. A United States Marine, no longer in active service, had a floating house, and the city of Riviera Beach went after him when he didn't consent to their development plan, as I understand what happened. They may have had a legitimate claim. They sued him in his house, his floating house, in the United States trial court under maritime authority. He went in pro se, hallelujah, and said no jurisdiction. What does a pro se say when they go into court? No jurisdiction. Okay. Trial court clobbered him. The appellate court clobbered him. He goes up to the Supreme Court, and in process there, City of Riviera Beach had to post a bond. City of yeah, sure, easy for me to say. City of Riviera Beach, Florida, posted a bond, and then destroyed his floating house. And then the Supreme Court said, "Why don't we take this case?" And they did. Long story short, there's several aspects of it, but in the Lozman matter, the Supreme Court defined or confirmed the definition of the term transportation. The term transportation is nowhere defined in the state transportation codes by whatever label. Transportation code, motor vehicle code, traffic code, they do not define the term transportation. The whole code is based on this term and it's not defined. You've got to start raising an eyebrow about why that's the case. The Supreme Court in the Lozman matter confirm Lozman's original pro se position of no jurisdiction, and here's how they do it. The popular trial court, appellate court rule of thumb was if it floats, it's a boat. Now that may be good common sense, it may be just fine, but now we're getting semantical. Boat is not jurisdictional. Vessel is jurisdictional. To have maritime jurisdiction, you have to have one of five things, one of which is a vessel. Inland waterway, coastal waterway, this sort of thing. One of the items there's a vessel. Okay, a vessel isn't a vessel unless guess what? It's used for transportation. Begs the question, and this is where this ruling goes. What does transportation mean? Finally, in part 4, they tell us that it means carrying passengers or cargo. Carrying has the commercial term to it. We look up Black's Law Dictionary for that, and it says for a fee. And that's the whole thing about transportation. So they weren't as overt about it as I am, and I expand on that definition this way. Transportation means removing people and or property from one place to another for hire under the choice of law of the place called this state. That's transportation, the key part being for hire. What the Supreme Court did in Part 4 of their ruling was say, we don't see any evidence of commercial activity. We don't see any cargo. We see furniture on the boat. We see that which would come with the floating house, but we don't see any use of that commercially. And the Solicitor General suggested, well, maybe we go send that back to trial for more evidence. The Supreme Court said, we don't need more evidence. We're not going to get anything new out of this. The boat was towed where it was. He doesn't use it commercially. They don't have any evidence of transportation. He hasn't rented out his boat. He's not doing passengers or cargo for hire. Therefore, no transportation. Therefore, guess what? No vessel. Therefore, guess what? No jurisdiction.
Well, good for him. What's the Marine's name? And
Lozman, Lozman. Lozman is his last name.
Is it, so that should be easily searchable on the
internet.
internet.
You'll find it, yeah. Lozman v. City of Riviera Beach is the case style. It's a 2013 ruling. And then the case kind of goes quiet. I was expecting to hear all the litigation.
When did it go to the Supreme Court?
Because the trial
when?
It would have been either the 2012 term or the 2013 term. Mm-hmm. The ruling came out in 2013. So it's very recent, and it's a opportunity staring us in the face for those who study transportation. You mentioned the sovereignty people. The prosecutors, the judges, the police officers across this country have been politically indoctrinated into the sovereignty movement. And the sovereignty is a political response, not a commercial response. It's a political response, and the sovereign they say they're ambassadors of is not recognized by treaty anywhere in the United States. So they may be ambassadors, but they don't have any ambassadorial or godlike immunity because their place is not recognized by treaty. It's the kind of thing, okay, they go halfway and they leave off the most important part. Where's your treaty? Where, where's the recognition of ambassadorial level stuff? Where's your treaty? They don't have one.
Yeah,
Bless their hearts. It's a
you know,
political position.
it's
The
amazing.
commercial position is I'm not in transportation. Now I have to be careful with that. It's just like talking tax. You can't win this thing saying just I'm not in transportation. There's more to it than that. I say that just to say that there is a defense for transportation matters. And why does that one push my button? Because it's another banking function. The income tax is a drain out of the money supply tub. Okay, the faucet is the loan in, and the drain are the taxes and fines and that sort of thing back out. The transportation system is a scam on the people. That we are not told the whole of it. They hide the definition of transportation. Why? It's a banking function. If we understood transportation, we would not participate. The cops would not enforce it. The prosecutors would not prosecute. The judges would not convict because they know it has to be commercial, and there's no evidence of that. Okay, so the Losman case is huge. This is where I'm headed. The Losman case opens up the entire area about transportation. And so the timing of it couldn't be better for what we're doing. And it's just another reason we sit at the feet of the Supreme Court and take notes. They're up at the front of the room. We're at the desks in the room. They teach, we listen. We ask questions, they answer them. They answer every question they ever asked. Sometimes it comes in cert denied. But if you ask 13, 15 questions, they say cert denied. They're saying all your questions are missing the point. We can't help you today. Okay, lots of learning going on. Well, lots of teaching going on. A little bit of learning going on. Losman is one of the more recent cases. On the other side, I had predicted the DOMA case the other way, the Hobby Lobby case the other way, and so we've got a whole new area in here that has to do with marriage. It's not one of my mainstays, and not in my wheelhouse, in other words. The Congress through DOMA, the Defense of Marriage Act, said we want one man and one woman, and the Supreme Court said you can't say that. But that's the only thing the Supreme Court said they couldn't say. So now at national level legislation, we have the commercial family. Traditionally, that's been state. Licensing at the state level of the family has been a state issue. Now it's a national issue. Okay. We're going to watch that transition because what they're saying is it's probably going to dwindle away from the states.
Yeah, but we need to come back to the idea that there are two different markets here.
Yes.
Not two different levels of society. We're talking about something commercially.
Absolutely.
And people have to understand that that is a commercial distinction that is going on, and it has nothing to do with anything regarding the Constitution or anything else.
Correct.
We are
religion in particular.
Pardon me?
Has nothing to do with religion.
No, you know the incorporations got into the business of licensing marriages.
Yes. That's
Now
exactly right.
you could argue all kind of position, because of incest or whatever that, and they can give us all kinds of excuses historically that we can look at. But they just got in the business of licensing marriage. That's what happened. Now that was
the offspring.
Right. Well, sure, but that was a commercial issue for the states. Now, when you kick that up to the Supreme Court, now we're getting into the different market now, because now they're saying, okay, all of these state markets will now adhere to this. Is really what's going on. Am I correct in that?
Yes. We're talking about a nationalization of the commercial family.
in markets.
Yep.
In commercial markets.
Correct.
Nothing to do with the Constitution of the United States.
Correct. It's 100% voluntary.
That's correct. What a conundrum, Harmon.
And it's so simple. I mean, we climb this cliff that basically we're climbing backwards, you
Right.
know, to get to the top of. It's not easy to get here. And once we're sitting on the top of the mountain, it really looks pretty simple.
Yeah.
It's in concept, it's simple. In application, it's still very difficult. We've got some bad habits to work out.
A lot of bad habits. Well, Harmon,
we're getting there. Programs like this, we're getting there. It's so exciting that you're interested in this.
We will. No, the Critical Post Chicago wants a long relationship. We want to get as much information that is correctly formatted in the hands of folks that are receptive to the information. Can't do anything. Yeah, can't do anything about folks that aren't receptive to the information.
Correct. We can't reach them, and we can't even really spend a lot of time worrying about that.
No, we can't.
We go with the ones who are interested, and that's the only people we need really to be responsible for.
Yeah.
And we are responsible for them. They have to understand what we're teaching them,
right,
and not muddle it. But we get them the straight word. Trust me, the truth wins out. It always has. They'll get it.
Yeah, and these are facts.
Yes.
This is a fact. You are in a market, folks. There's a state market and there's a federal market. And we're all using these little green things called Federal Reserve notes, which means that we are consenting to be governed by the Uniform Commercial Code and the United States Code if we transact and exchange value for services with these things. Now you understand that you've consented to the system, whether you knew it or not, whether you wanted to know it or not, whether you liked it or not. You have consented, and that's the gotcha. And there's very few people in the system, even in the system, that understand that form of consent. And everything that you're reading about the Constitution, all these conspiracies, all this stuff is a bunch of garbage because it has nothing to do with the actual legal reality, whether you like the legal reality or you don't. Am I stating that?
That sounds terrific. You're telling them straight word.
Yeah.
And the thing that I go on, just to supplement where you're headed, the ideas that we're raised on are political consent ideas, and it's deliberately distracting because what governs right now is the commercial activity, the commercial behavior, the commercial consent. And you see, this is why groupthink doesn't work. It's why the politics doesn't work. We're not talking about a political problem. We're talking about an individualized commercial problem, which means the solution is also with the person we see in the mirror.
That's exactly right. It's from one standpoint, it's very simple. From another standpoint, it gets very complex.
Very complicated.
If you confuse the one issue with the other, what we have is a bank that's in part a private corporate bank that has private member banks. It's in full partnership with something that they call the federal government, which is a corporation. And we have this partnership, and what they're doing is they pay lip service to the Constitution in a form of kabuki theater to keep you under the idea that, oh yes, we honor free speech, or oh yes, we honor the Second Amendment, oh yes, when in fact, if they feel like not honoring it, they cannot honor it, and it's 100% legal, and that's why you couldn't do anything about it. Because no court that is a federal court, circuit court, whatever, that is a member court of this federalized system is going to uphold anything regarding a challenge to that whole thing. Because they're part of it.
If we've agreed to a position, then it's counter to what we think we've got a right to do. This is the Heller case, the fellow out of D.C. D.C. did an ordinance to try to disarm people in their homes.
Yeah.
And the Supreme Court, the appellate court, the D.C. appellate court, and the Supreme Court both said, no, that statute's not going to, that ordinance can't stand. But they also said, we're not saying that regulations on Second Amendment stuff is bad. And what they're telling us, what they're teaching us is there are certain things that the government people want to seduce us into agreeing to, and there's a limit on them. But the things that they can seduce us into agreeing to waive our right, for example, to be armed, they can do that. So this again, it just to give you an illustration, traveling is not something subject to regulation on the Second Amendment, but transportation is. If we're in transportation, we've agreed to be regulated and therefore agreed to be disarmed unless we've got a concealed carry permit. If we're traveling, it's not an issue that comes up. And again, this is not something you just go rush out and apply because you heard it on a radio program or a YouTube thing. It's just the intro to the concept to say there are solutions to this. Now, we do have rights and they're recognized, except the system is designed around seducing us to agree not to have them. It's the right not to contract. Everything comes down to the right not to contract. When we understand that that's where everything in this system stops and starts, where it starts and stops, now our mind is going to start asking the right question. Well, where did we agree? Now we're talking about the right issue. Where did we agree to that? Well, let's go find that out.
Right. Just check your pockets, ladies and gentlemen. That's all you have to do because that's when you agreed.
That's one of the ways.
Just check your pockets. I mean, that's the issue we're addressing here is the federalized system and what federation means and what you ran across as a result of being basically handed your whole life in your hands from what you understood was one thing when it actually in that litigation in Terre Haute forced you to recognize as another, which led you down this whole research path.
Yeah, that's right.
Amazing. It's amazing. But I'm glad that I ran across you. I don't produce a lot of content at the Critical Post Chicago because I want it to sink in. And this is an interview that I want people to get their minds around because there's a certain audience that we have that is paying attention to all this stuff and they have to get their minds around it. Now,
Yep.
If they're taking money from the federal system because they're on disability or whatever, realize that the banks are just being nice to you. That's all. That's basically what it comes down to. They're just being nice, and exactly how nice, well, that's another story for another day. Harmon, I'm going to take it to the end of this. People can get to you. They can email you at legal_reality@earthlink.net if they have any questions. You have a consultancy, right?
Correct.
And you perform your consultancy for the trade in silver. Is that correct?
Correct.
That is the only way that you'll do business is an honest weight and measure.
Correct.
Will you take copper pennies? Just
copper,
kidding.
Copper pennies that aren't U.S. related, sure.
So in other words, even if it's a minted, you would rather not take a U.S. minted coin.
Correct. If there's the preference,
Okay.
the pure metal in its long and short there is the U.S. stuff really isn't what it purports to be. With 90%, 70%, even the 40%, they purport that it has something to do with the original standard and the original troy ounce and the original THALER system, the Thaler, from which we get the concept of dollar. And they used a value. When they first coined the stuff, they used a market value of silver to get the dollars and the quarters and the dimes. It wasn't a troy ounce. Not that a dollar has to equate to any particular weight. It's just that was the suggestion. We're going to have a dollar be a troy ounce. Well, it never really was. And so even those coins that are silver, and the answer to your question earlier is 140 in face value. $1.40 in face value of pre-64 silver coins is 1 troy ounce of fine silver. And so,
Well, according to today's market, I mean, that can change at any time because,
yes, the weight should be the same. In other words, if you have 4 quarters and 4 dimes, whatever their value is, those coins, if in the original weight, constitute 1 troy ounce fine silver.
okay, okay. Well,
So,
anyways, people can contract with you, but
yes,
they can't contract you with Federal Reserve notes.
that can't happen. We missed the entire point of the lesson, which is to say that stuff, the Federal Reserve note stuff, is poison to this nation, and I can't say that any more seriously.
No,
It's
I agree.
destroying us,
Yeah, I
and we've got to stop using it. We've got an addiction. It's going to take us a while to get loose from it. It's poison, and so that's just part of the lesson in this study, which is this book, is the teaching of honest weights and measures. And I
right.
prefer the silver bullion, the silver rounds, because they have nothing to do with the concept of dollar. There was this guy that did the Liberty coins. You may have heard of him. He mixed and matched choice of law, and he ended up in court. Van Nothouse, if he hadn't have mixed choices of law, put the term dollar and the symbol dollar on his troy ounce fine silver Liberty coins, he'd have been fine. He would have just been another minter. Not mentor. Another person doing minting of coins. He would have just been one more, and that'd have been fine. He mixed the choice of law, and the Treasury is the only entity that's got the license
To use the word dollar.
correct, to mint dollar into troy ounce fine silver coins.
Right. Now,
So that's where he got sideways.
And the name of that book, again, is The Posterity, Voluntary Bondage. There's no website for that, right?
Correct. I'm not on the website. I figure it's too vulnerable, and I don't have time to do all the correction of websites. So I do emails and radio programs, video programs like that.
Okay. Well, ladies and gentlemen, again, you've been listening to the legal mind of a computer expert and a person who I have come to have a high esteem for in terms of the information. His name is Harmon L. Taylor. He is, again, a graduate of Southern Methodist Law School. It is his quest to understand what happened to him at the Terre Haute litigation, whereby he was arguing for the preservation of evidence on behalf of victims of the Oklahoma City bombing. Then that was in 2003, right, Harmon? That the Terre Haute litigation came about?
That was May and June of 2001. It was right before
okay.
S11.
Right before September 11th. And it was as a result of that litigation and what the courts told him that he was of no authority when he was arguing the Constitution that led him down this road to understand really what the heck was going on, which is why we wanted to have this interview with him so that you could understand, ladies and gentlemen, that if you use that green stuff, you're consenting to a rule of law that has nothing to do with the Constitution of the United States of America. And everything that you've learned about the Constitution of the United States is not why you're consternated at watching elections and all this other stuff and all this conspiracy. Why you're consternated is you think they're supposed to be following the Constitution. They don't have to follow the Constitution. There is nowhere in the Uniform Commercial Code or the United States Code where the Constitution of the United States of America is even mentioned. To our knowledge, or at least to my knowledge, I haven't seen it. So, ladies and gentlemen, with that, again, my name is Scott Pollock. I am the chief editor of the Critical Post Chicago. And thank you for watching another interview sessions. Mr. Taylor will be back with us to explain other matters as time permits, and we will contribute more to the series. Harmon, I really appreciate you coming by and spending some time here.
I really appreciate the interview. I enjoy supporting your efforts there. The essence of the problem has to get out. And journalism is at the heart of what makes America different. And you're doing journalism the way journalism needs to be done, which is let's get to the essence of it.
Well, I'm trying to do news reporting. I have a problem, and I don't mean to reprimand you. I have a problem with journalism because journalism is telling a story.
Okay.
And it's the journalists in this country that are muddying the waters really bad.
I'll stand corrected on the point.
Well, and if just as a matter. But again, it is a pleasure to have spoken with you. Thank you very much for taking the time to explain to people what the heck is going on in this country and why they are frustrated and what they don't understand.
Thank you for the opportunity to do so, and I look forward to the next one.
Thanks, Harmon. We'll talk to you in a little bit. Thank you,
See you next
ladies and
time.
gentlemen. Thank you, ladies and gentlemen. We'll be back with another report very shortly. Again, my name is Scott Pollock. I am Chief Editor of the Critical Post Chicago. Have a good tomorrow.